Hello and welcome to another episode of the Inside R&E podcast. I'm your host for today, Devin Kosar. I'm a member of the firm's Litigation Department and head of the Violations Department at R&E. Additionally, my practice includes matters related to construction law, condo co-op law, landlord-tenant issues, and commercial litigation. On today's episode, we'll be discussing more in depth about the Climate Mobilization Act, also known as Local Law 97. We'll talk about the issues to be aware of and how you can identify and avail yourself of potential programs and mechanisms in place in order to navigate through Local Law 97. Now, if you've missed our first episode on this exhilarating topic, that dropped back in March 30th. You can view it on YouTube or listen to it wherever you get your podcasts. For those listeners that are not familiar with this topic, the Climate Mobilization Act, or Local Law 97, was enacted in the beginning of 2019. However, with the advent of COVID, people really didn't seem to pay attention to this issue until probably around last year or so. The goal is to ambitiously reduce greenhouse gas emissions in New York City. Local Law 97 affects a large percentage of landlords, building owners, and commercial tenants, both now and in the foreseeable future. My guest for today's episode is Alex Zafran, Director of Business Development of Logical Buildings, where he partners with real estate owners and managers nationwide to cut energy costs, enhance efficiency, and lower their carbon footprint. Alex's expertise spans across various sectors, including energy, commodities, and financial markets, energy procurement, solar generation, and smart buildings technology. His insights on New York City's energy landscape for co-ops and condos have been featured in Habitat, Brick Underground, The Cooperator, and many other industry publications. For buildings subject to Local Law 97, Alex's primary goal is to eliminate the fear and uncertainty and doubt that many are feeling right now and replace it with a clear path of action. Alex, welcome back to the show.
Good to be back, Devin. Thank
All
you.
right. So please tell our audience a little bit about yourself again, for those of you who aren't familiar, and how you got into this industry.
Sure. So, good to be joining you and the whole R&E crew again. Um, I've been in this business just really since the start of my career. When I say this business, I mean the interesting nexus of energy and real estate, specifically focused on working with condos, co-ops, and property owners and managers throughout the United States, really to manage their energy costs and to understand what it is that's happening behind the scenes. So energy compliance is something that New York City has become familiar with, but it's something that owners and managers of buildings across the country are now waking up to. This is a reality that's setting in places like Boston, where carbon fines are arriving, in California, and other large cities. It's not going away. And ultimately, at Logical Buildings, our goal is to help buildings not only take care of the one time item of energy compliance, but we want to help buildings make changes between those compliance periods so that they can improve. And most importantly, we can deliver value to the owners, to the shareholders, and enhance the longevity and the quality of the assets that are being owned.
Uh, so what's been going on since the last time we spoke?
One of the things that we're working on is partnering with one of New York's largest owners of commercial multifamily real estate, soup to nuts, to design an energy efficiency program for them. We work with multifamily, commercial, and industrial clients across the country, and we know that work is not limited to energy compliance. It's about data. We're currently working with one of the largest owner operators of real estate in New York City right now who knows that compliance has to be addressed. And beyond compliance, we're thinking bigger. We're thinking 5 years out. We're thinking 10 years out. We're implementing programs that will not only help them reduce their carbon fines, but help give them visibility into the energy they use to help them actually earn revenue from Con Edison through a unique program and to help drive their sustainability and their company corporate metrics to be exactly where they need to be.
It's great. Yeah, it's obviously, it seems like, when we're in New York, in New York City, we have this little bubble, but obviously, there's wide-reaching effects across the country, it seems like. So before we dive into it, Alex, why don't you give us a brief recap for our audience, overview of Local 97, who it affects, and some of the main highlight points.
Sure. I don't know if this will be as, let's say, as riveting as the typical, in case you missed it, recap for shows like The White Lotus and others, but we'll try to make this interesting for the audience. So, as you said, Devin, after years in the making, finally, Local Law 97, really the most stringent energy compliance law in the country, is coming into effect. And buildings 25,000 square feet or over have to start reporting their carbon emissions. If they exceed that limit, they'll be fined. And if they fail to submit the compliance report that's required of them, they'll also be fined. The carbon emission limits that buildings are subject to will change over time. So right now, even though many buildings in New York City won't be facing carbon fines, that's going to change starting in 2030 when the amount of emissions that buildings are allowed to use drops, the laws become more stringent, and about 66% of New York City buildings are estimated to pay some fines. Those emission limits will continue to decrease, i.e., intensify every 5 years thereafter. It's important to note that different buildings have different ways to comply. The main divisions are for buildings that report annually versus those that have a certain amount of rent regulated units and have a one-time compliance path. And it's important that you check with your registered design professional or your energy consultant on the right path for your building. This whole process is predicated on energy data, and it all goes back to two elements. Number one, the energy consumption that is recorded for your building, and number two, the property details in your building. So for every building that's participating in this process, whether they've been preparing for it for a while or they're just starting the process of energy compliance, data is really the key to making the difference between proper and improper compliance.
So you touched on something regarding data and registered design professionals. So I'm gonna piggyback off of that, and you know, but before I do, I just want to also talk about some of the upcoming deadlines that are approaching with respect to recording, compliance, potential protests and whatnot. If you could just
Hmm.
touch on that as well.
Sure. So there's been a lot of there's been a lot of movement over these past few months, much of which is actually favorable for owners and managers in New York. So firstly, the deadlines for Local Law 97, Local Law 88, which is a one-time compliance item surrounding lighting and submetering, and also for Local Law 84, energy benchmarking. The deadlines for those three laws have all been pushed off from May 1st to June 30th. Buildings now have an extra, well, we're at 53 days and counting in order to meet their compliance without any repercussions for filing in that period. On top of that, buildings that may need extra time do have the opportunity to file until August 29th if they'd like for Local Law 97 and Local Law 88. Benchmarking, unfortunately not, but if your registered design professional or your building needs that additional time, you can take those actions to secure it.
So, right, you talked about the importance of hiring a registered design professional right away, to navigate this process and review the information to make sure it's accurate. Now, I want to get into that data and examination because it's twofold, right? It's input data who the landlord or the owner is going to have all this data, and the question becomes, is it reliable? Is it accurate?
Mm.
So talk to us a little bit about that and this process because, as we've said, on its face, it's not just am I a covered building or not, because it's also examining the data and making sure, like I said, that it's accurate because it's going somewhere. Someone's reviewing it. The city is going to be reviewing it based on certain characteristics, how the building is occupied and used and operated, and that's going to depend on what your output is, right?
So actually, Devin, I'm glad you brought up the word RDP or the phrase registered design professional because I realize it might not be common to everyone who's
Yeah.
listening. Um, technically, registered design professional is the catch-all term that New York City has applied to professional engineers or registered architects. So essentially what we mean when we say this is when we talk about something like energy benchmarking, which uh, requires buildings to submit their annual energy usage every year, when that's been done in the past, technically buildings have been able to do that themselves. It's a number crunching process. It's a mind numbing number crunching process, I will add, but they can do it themselves. Whereas for Local Law 97, the city does require the appointment of a registered design professional, an RDP, to certify that the calculations being done about your building and the amount of carbon they use are accurate. So it's important to note that. But reflecting on this data from energy benchmarking, as a reminder, this is really the source. All of the data, all of the determinations that are made about your building come from this energy benchmarking that technically is due now, but again, has that extension period until June 30th. So if there's a flaw in that data, it means there will inherently be a flaw in your Local Law 97 reporting. And what I tell to many owners, operators, managers, executives before they throw resources and time and capital into expensive projects, I say, when was the last time you checked your benchmarking? When was the last time you did quality control on that? And we've seen time and time again buildings that actually have been able to lower their carbon fines and reduce their impact just by scrutinizing the data. It's a very underestimated and I think underutilized form of energy management just by making sure that the inputs are correct.
So, Alex, I want to. I think you hit on a really important issue here, but I want to just also talk about some of the nomenclature here because I think what's different about this particular Local Law 97 Climate Mobilization Act is they're using a different term, right? This gross floor area versus the typical gross square footage, or it's a different measurement, right? With other energy input and data that's being typically recorded and measured through other city agencies, right?
That's right. So the metric that most buildings are used to is what they see from the Department of Finance, and it's referred to as GSF or gross square footage. If anyone was to Google their building right now or pull up one of their records, they would see a gross square footage number. But the Department of Buildings, which is administrating Local Law 97, is actually asking for something more robust. This gross floor area number represents a larger swath of area and includes spaces that the gross square footage, the Department of Finance number, doesn't usually include, such as basement spaces, elevator shafts, hallways, atriums, elements that are technically within the overall construct of the building, but may not be included for rent or occupancy purposes. So when it comes to Local N97, it's imperative that buildings use that gross floor area figure. And more importantly, the Department of Buildings actually expects them to have a document to back it up. So even if a building says that hypothetically they are really 65,000 square feet, as an example, but the Department of Finance number, the gross square footage, says 50,000, the Department of Buildings is going to ask, well, how do you know? So our job is to help buildings prove that the square footage, this gross floor area, is what they really say it is, and the benefits that come with it will allow buildings to actually reduce their carbon fines.
So this is the $64,000 question. How do you get that document that they're going to require?
Yeah. So we've seen, let's say, a wide variety of different approaches to document management in New York, depending on the way that buildings will keep track of their information. And some of the acceptable forms that we've taken and that we've seen include field surveys, visual images, archival drawings, condo declarations. We'd like something with a little bit of oomph, for lack of better words, something with a stamp or signature from a prior engineer or architect who was involved in the project, or excuse me, in the construction or the design. And if for whatever reason those documents aren't available, we'll do something called a gross floor area study, which means having an engineer actually go to the building. And this is important not only just to keep track of the total gross floor area, meaning the overall size, but also to take the measurements of individual space types within that building. This is critical for mixed use buildings, whether it's multifamily with ground floor retail or developments that have a combination of office, bank, restaurant, medical, etc. Keeping track of those individual spaces is critical because the way the city looks at the carbon emissions of each of those spaces is also different.
Well, I can't tell you how many times I've had conversations with clients where we get to this stage, right? And the question becomes, they want backup. What are we presenting? What are we basing this off of? Well, we're using what we used for Yardi in our accounts receivables with our accounting department and things like that. And I think it's important to explain, and I want to emphasize this a little bit more. You know, what's the risk or the downside of using the gross square footage versus the gross floor area?
Hmm.
Because a client could say, I don't want to deal with this. What's the difference, right?
Which
And
is
it's really not.
yeah, which is frankly understandable. And I've had many questions from clients about why this is critical, and I
Yeah,
come back to them with two reasons. Number one, when the registered design professional is going through the local law 97 submission process and they press send on your building, from what we understand, there's essentially going to be an automatic flag in the system if the gross floor area number that's entered is exactly the same as that gross square footage. So the Department of Buildings has been aggressively hiring auditors and engineers to actually reach out to buildings after their submissions. And a building that submits a number that doesn't differentiate can expect to get some sort of response asking for proof. And if there's failure to give that accurate number, there could be repercussions. That's the stick. The carrot is the fact that what we've seen is based on that statement earlier that the Department of Buildings doesn't necessarily account for additional areas. It's actually advantageous for buildings to have a gross floor area metric that's bigger. And the reason being is if you have two buildings that are using the same amount of energy, let's say they're right next door to each other, and one building happens to be a floor taller than the other. That building that's a floor taller, that's using the same amount of energy, is technically more efficient because it's doing more with that same amount of energy. So time after time, what we see when we do these gross floor area studies is that buildings have been underrepresenting their total square footage. They've been using a gross square footage number. They've been using a Department of Finance number, which is lower than reality. And by doing this assessment, by doing this study, they've come back with a larger space that not only will reduce their carbon emissions for that current compliance year, but also carries forward into the future.
but I'm sure you've seen these types of, I'm sure you've had some interesting examples of this, right? When you're dealing with these gross floor area studies, and people that, because again, you can look up your address, right, and you can see what your potential what the potential penalties might be, but again, proof's in the pudding because as you mentioned before, if it's input, if it's garbage in, garbage out, so it depends on what this data is and how it's being recorded and what you're looking at, right?
Yeah, yeah. I've had there are two recent endeavors I was working on, and again, you do this in my world. You do this with a smile on your face because every building is different, and there are always twists and turns waiting for you in the process.
Right.
The first was this was a multifamily building that for 2024, when I say 2024, what I mean is the current filing that's happening right now reflects energy usage from 2024. It's
Right.
akin to tax years.
Right.
So this building looked as if for 2024, its carbon emissions were at 110%. And they were looking at an annual fine of $15,000 starting in 2030. So again,
Right.
they have fines for the next 5 years, and that fine amount jumps in 5 years because the amount of emissions they're allowed to use is lower. So when we were going through this process and looking at the data, we noticed that the Department of Finance number was exactly the same as the gross floor area. And it's certainly not the building's fault. We called it to their attention and we said, has anyone thought about looking at this? And they said, no, we didn't realize this was something we could address. So we sent out one of our engineers to measure the space. And what they came back with was the spaces, the gross square footage from the Department of Finance completely ignored the cellar areas and the hallways in the buildings, which makes sense because when you look at condo declarations, it usually refers to the rentable or the square footage that belongs to the units, to the owners or the shareholders.
Right.
So the hallways weren't being included, neither was the below ground space. And it increased the gross floor area of the entire building by 15%. So not only did it bring them down from being 110% to under the limit, it also completely wiped out their fines for 2030 just by taking this action.
It's incredible.
And then this is data. This is data and an engineer. The other one that was very interesting, that was a little bit of a head scratcher to begin with, was a mixed use commercial facility in Queens. They were looking at fines of $12,000 starting this year for the next 5 years. And then starting in 2030, they were looking at about $32,000 per year. And there weren't reports or any signs of excessive energy usage. So we didn't really understand what was going on. And it wasn't until later that when we got the benchmarking report for this building, we saw that the entire building was being designated as a retail building. And going back to the earlier point, different spaces have different amounts of carbon. When you think about it, a restaurant is using different amounts of energy than a multifamily space, than a bank, than a nightclub, etc. And this mixed-use building had several medical offices. It had several restaurants. It had a small convenience store. It had a bank branch. And no one had gone into the energy benchmarking reports to correct this. So the city was looking at it like it was a completely 100% retail structure when in fact it was far from that. And just by going in to make those changes, we brought those $11,000 of fines down to about $2,700. And the building has already implemented energy measures that by the time they file next year, that $2,700 will go away. So even though they weren't able to completely eliminate the fine for this year, they significantly cut it, and they're now on a path to being at zero for next year.
That's incredible. I mean, again, it sounds so simple, and I may be repeating myself a bit, but again, it's the importance of getting a registered design professional here is it's imperative, because also this is all being essentially done for the first time. And what I mean by that is, this program's just been rolled out, and there's the submitters and the submittees. So on our side, our client side, they're doing this for the first time, but really the Department of Buildings and the City of New York are doing this for the first time too. So it's important to get connected with somebody that can guide you through this, because as expected, there are going to be numerous inquiries and issues that come up, and they're going to be raised for the first time that the DOB or the city may not have anticipated, and they might not even know how to answer it, and which causes more delays. And you shouldn't be in a situation where you're waiting on an answer, but you're going to hope that you'll be okay in the interim, because you could trigger a flag where you've registered it under the wrong article as a covered building, or you've had a late filing, and now you're subject to fines, and that's a whole another mess you're gonna have to untangle. So I think that's a really important thing to stress, to get somebody on board to help you go through this, because as you said, Alex, you shouldn't have to go through this alone.
Yeah, and you're right, Devin. Everyone is sort of figuring this out together. But what I try to emphasize with all buildings, especially as we now get down to the crunch time of sending these reports, is that this isn't going away. This
No.
is going to be a standard process. What gets submitted to the city, or the way it gets submitted to the city, will change. But this should become part of the repertoire of compliance that buildings have to face, or buildings should understand it's now part of their repertoire. And it goes back to what I had mentioned earlier, which is that we don't just want buildings to file once every year and say, okay, let's cross our fingers and hope that we'll be fine for next year. Buildings now need to start thinking about what they're doing between these compliance periods if they have those annual obligations, so that 10, 15 years down the line, they're not forced to pay these fines. They've already made decisions, they've already sowed the seeds and made the right investments proactively.
But and again, just to reiterate that you can be in a situation where for 2025 you may not be subject to any fines, but as this continues to step up, 25, 2030, 2035, the requirements and the caps become more stringent and more stringent. And what sooner or later, pretty much every large building owner is going to be subject to this one way or the other,
That's
right?
right. That's right.
So I think that's a perfect segue for the next thing I want to talk about, because I think for now and in the immediate future, as we stated, there's a lot of issues to navigate, but there's a lot of resources that are available for our audience and our clients that they may not be aware of, and that can put them in a better position with respect to Local Law 97. So, Alex, can you give us, or can you talk about one or two additional programs that at the top of our mind here that we can introduce to our clients that as an option here that they can use to navigate Local 97?
Sure. I'll say one thing from the financial side and one from the operational / engineering side. So many of the listeners may have seen the rebirth, the renaissance of the famous J-51 program in New York City.
Right.
It has been around since World War II, expired in 2022. Governor Hochul brought it back in 2023, and there's a new iteration of the program, J-51R, which is designed for buildings where 50% or more of the units are rent regulated, with rents below 80% of area median income.
To briefly update and educate our audience here, the J-51 program is a program that offers property tax abatement benefits for eligible construction work. This can apply to certain condos and co-op and rental buildings, but there are specific criteria that must be met. So it's important you consult with your Rosenberg and Essex attorney or contact me first to review and discuss this. I can tell you that one of my two of my other partners, Ben Williams and Daniel Bernstein, recently published a webinar on this topic that we can link to as well. But there's a lot here to uncover. But one of the things that caught my attention was how, and this is Alex, you can talk about this, is how the certified reasonable cost schedule in this J-51 program identifies different types of work that can be available for Local Law 97 compliance.
Yeah, the new iteration of the program, which is called J-51R, really was designed with Local Law 97 in mind. And what's interesting is that buildings that may want to undertake energy efficiency retrofits like upgrading their boiler or their HVAC, this is the time for them to do it. It aligns perfectly with the Local Law 97 deadlines, and most prudently, buildings that are subject to Article 321, which is the Local Law 97 path that requires 13 different energy conservation measures to be done. J-51 is calling their name. This is the perfect opportunity for them to take these actions that otherwise would be cost prohibitive and take advantage of the program now.
Excellent, great. I think it's a really great way to kind of cross sell or use the different programs that are available to quote unquote kill two birds with one stone, so to speak. So that's great.
And then on the engineering / operational piece, buildings over 50,000 square feet in New York have a law or have a compliance requirement called Local Law 87. And Local Law 87 requires these buildings, again, over 50,000 square feet. It's a subset. It's a different set than the other laws, to complete energy audits / retro commissioning every 10 years. which essentially requires a building to meet with an engineer and have a comprehensive report done about the entire energy state of affairs at their building, what can be upgraded, and the ROI of those measures. Now, I'll be honest, a lot of the times these reports get done, they're 100+ pages of engineering jargon and they sit on the shelf and they collect dust. And no one does them. No one does anything with them until 10 years later. So, in my mind, if this work is being done for the city of New York in order to avoid fines, people should put it to use. As buildings have their energy audits coming due, they should think about gearing that specifically towards local law 97. And some buildings can actually do their local law 87 audit 2 years early. So for instance, if you know that your building has an energy audit due coming up, and that you may be facing fines for local law 97 in 2030 or 2035, now's the time to actually commission that study. And what you'll be left with is a essentially local law 97 action plan from an engineer that weighs all of the different actions you can take with their costs and benefits so that you can make decisions now using the information that is required by the city.
That's great. It's always great to get your clients ready, informed. They can make decisions, and they're armed with choices, with options, right? That's what we talked about two of these potential topics, and it's a great, it's a very rewarding experience where you can have your clients and alert them and teach them of kind of savvily playing and using different programs that are there, to address other needs and issues.
Right.
One of the things that we keep saying is, we've said this in the past, is that, if you are an owner or an operator of a large mixed-use building, this will be an issue for you, whether it's this year or in the upcoming years. And, to get a plan that you can now talk to your principals, talk to your tenants, if you have potential issues with revising your leases, with green leases, where you're dealing with, here we're doing this at R&E, we're dealing with it now in our renewals when we're accounting for potential carbon emissions and how our tenants are dealing with these potential increase in costs or fees. And this is the time, right? This is, as you said, having that Bible, so to speak, to use it going forward is just, it puts you in a much better position so that you can pivot where you need to and how to, tackle anything else that's going to come up in the future. So, I think, Alex, like any sequel, there's more of a story to tell here. This is our second episode, and perhaps we have a third one or a trilogy, right?
It's true. We've seen how trilogies do at the box office, but it's up to the powers that be at R&E whether I'll make the cut or not.
Well, I think we're on our way. We just celebrated Star Wars this week, so it's another famous trilogy. So
Right.
maybe we'll have to come up with a more clever title.
Right.
Great job, Alex. The contact information will be in the show notes. But Alex, if you can if you want to plug your information for our audience or listening audience.
Sure. Anyone who is handling energy compliance, has questions about energy, or really thinking about and open to what else can be done for their building, Zafran at logicalbuildings.com.
Okay, great. And once again, these issues, there's a multifaceted component, whether it's legal, whether it's data, energy, usage. So, you can contact me or your trusted Rosenberg and Estes attorneys. I'm at Kosar at rosenbergestes.com. I can be reached at 212-551-1208. Alex, once again, great job. This has been super informative. And this has been another edition of the Inside R&E podcast. I am Devin Kosar. Thank you so much for joining us today.
Thanks all. Thanks, Devin.